Hello friends, in the series on the income tax cases today we will discuss a very litigious issue which talks about that whether the shares and mutual funds held by the assessee will be treated as business asset or as an investment, or the gains which will be arising from their sale, whether it will be a capital gain or a business income. This issue has been taken up by the Kolkata ITAT A bench in the case of Srimati Yamini Khandelwal versus Assistant Commissioner of Income Tax, which has been reported in 117 ITR Tribunal at page number 417. The matter has been decided by Kolkata ITAT and the date of the judgment is 27th September 2022. In the present case, the assessee was dealing in derivatives and the assessee was also holding the shares and mutual funds regularly, and the assessee was showing these shares and mutual funds in her income tax return under the head investments and not current assets. But because the volume of the transactions was very high, the assessee has also borrowed the funds. So the assessing officer during the assessment proceedings took a view that these shares and mutual funds are also held as a stock and calculated the income of the assessee from the sale of shares and mutual funds under the head business income instead of capital gains, meaning thereby that the assessee has showed the income under the head capital gains, but the assessing officer treated it as business income. When the assessee took this matter to the CIT appeal came out with a totally different concept. The CIT appeal said that the shares and mutual funds which have been held by the assessee up to 3 months will be treated as business income, and the shares and mutual funds which the assessee have sold after keeping more than 3 months but within 1 year, the gain of sale of those shares and mutual funds will be taken under the short-term capital gain, and the shares and mutual funds which have been sold after 1 year will be taken as long-term capital gain. This was totally a different concept. The assessee was before the tribunal. The tribunal, while dealing with the matter, said that there are 2 circulars of the Central Board of Direct Taxes. One circular is circular number 4 dated 15th June 2007, and the another circular is circular number 6 dated 29th February 2016, which provides the guidelines to the assessing officer for determining whether the shares and mutual funds are held as investment or stock. This circular says that there is no single principle for determining the nature of the income. One has to see the totality, the effect of the totality of the principles in a given case. The main concept is that the intention of the assessee is to be seen whether the assessee holds those shares and mutual funds as stock in trade or as an investment. In the present case, the intention of the assessee was very clear from the fact that the assessee has shown shares and mutual funds under the head investments and not under the head current assets. Tribunal further said that in the present case, the order of the CIT appeal is not as per law, and the tribunal said that since the assessee has shown the investment into the shares and mutual funds under the head investments, so the intention of the assessee is very clear, and the income which is there from the sale of shares and mutual funds is to be taken under short-term capital gain or the long-term capital gain depending upon the period of holding. So the tribunal gave the relief to the assessee. Friends, this case is very important. We have to read both the circulars, circular number 4 dated 15th June 2017 and the circular number 6 dated 29th of February 2016. These circulars gave a very good insight into the concept and the principles for determining whether the income from the sale of shares is to be treated as business income or the capital gain. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Shrimati Yamini Khandelwal versus Assistant Commissioner of Income Tax, and this case has been reported in 117 ITR Tribunal at page number 417. The matter has been decided by Kolkata ITAT A bench, and the date of the judgment is 27th September 2022. Thank you, friends.